All right, court is calling 2022 CR 1107 State versus Angel Cantu. Could I have parties announced?
Rick Pena for the state of Texas.
Warren Gary for Angel Cantu.
And are you Angel Cantu?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Angel Antonio Cantu who's placed on deferred adjudication in 2022 CR 1107 for the offense of indecency with a child's sexual contact on August 25th, 2022 for a period of 10 years? Is that you?
Yes.
State?
Yes, Your Honor. Violation condition number 13A. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to having internet identifiers on Discord, Kick, and other social media platforms. Violation of condition number 13.
How do you plead to that? True or not true?
Sure. Violation condition number 13B. On or about the 16th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, in that the defendant failed to progress toward reasonable treatment goals and was terminated from treatment in violation of condition number 13B.
How do you plead to that? True or not true?
True. Violation condition number 13JA. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there failed to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to accessing the internet on an unmonitored device in violation of condition number 13JA.
How do you plead to that? True or not true?
True. Violation condition number 13L. On or about the 11th day of
Let me just stop you all. Are you all doing 13L but not 13F?
13F and 19 are going to be waived by the state.
Okay. Do you really need 13L?
You can waive 13L as well.
No objection, Judge.
All right. Did you understand by pleading true to 13A, 13B, 13JA, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to 13A, 13B, and 13JF?
Yes, Your Honor.
Court will find 13A, 13B, and 13JF true. Is there a proposed agreement?
There is, Your Honor. That is to grant the state's motion, revoke the defendant's probation, adjudicate him guilty, and sentence the defendant to 8 years in prison.
All right. Why should I follow this?
So Judge, Mr. Cantu so these allegations arrive from Mr. Cantu's own statement. So he was self-disclosing of these things during the process of which he was getting treatment for under the sex offenders program. He had been asked by his counselor, through the various ways they go through counseling, how are you doing? What's going on? He self-reported these incidences. The thing that what I understand from how I've looked at this case is that my client has had struggles with doing probation. I think ultimately probation is good because it helps us find these issues where we have problems that kind of relapse up. I think given that Mr. Cantu has indicated, we're here today because he's not hiding anything. He's not proud of what he did, and he has indicated to me that he understands that this is, it's not good, and he, shouldn't have been doing it in the first place, Judge.
So has he had contact with the complainant?
Judge, it is my understanding that he has not. I do have the mother of the complainant here is present. If you would like us to call her, Judge.
I mean, well, you talked to her. She's saying that he hasn't had contact?
That is what she said, Judge, and I understand that's only her statement.
All right. And how old is the complainant?
I'm going to get her.
How old is the complainant?
My mother. 14, Your Honor.
Okay.
Judge 14 at the time of the.
Can I get that? Yes.
I do remember this case now. And I'm sorry, could I have the trial court certification? All right. And I'm sorry, State, why should I follow your agreement?
In the continuation of justice with this coming about. Fair prison sentence from the state point of view.
I'm sorry?
It's a fair prison sentence from the state point of view.
So what has he done on probation?
I'm sorry, his probation officer was here a little bit earlier.
Okay.
But according to the court summary, there has been 3 negative UAs. He was in sex offender treatment, but there was some issues there. As far as anything else, he was on the so moved caseload, but there's a total credit of $1,163 toward his supervision fees. But other than that, Judge, nothing.
Are you asking the court to follow this agreement?
Yes, ma'am. Yes,
Are you
ma'am.
waiving your right to appeal?
Yes, Your Honor.
This is the full weight of a felony conviction crashing down. 8 years in prison, lifetime registration under Chapter 62, no contact with minors, no weapons, even after release. These consequences don't end at prison gates. They follow for life.
All right, the court will revoke, find you guilty, sentence you to 8 years in the prison. There's to be no contact with the complainant, no residing in households with minors, no contact with minors, and Chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement? Oh, I'm sorry, I need that back. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Could I have his file back, please?
Yes, ma'am.
With the trial court certification. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
Sure. All right, good luck to you.
Thank you, Your Honor.
All right, who else has a contested hearing with witnesses?
Mine is separate contested, but we spoke yesterday
Yes.
about getting.
Who's your client?
His name is Alonzo Taylor, Judge. He hasn't been brought up yet, but I have her
Oh,
Scalloway.
what page is Alonzo? Oh,
Page 18.
18. All right, Norma, if you can set this, it's set for a contested. If you can set it for the 3rd week in January.
I can do the 22nd,
The 27th?
the 22nd?
All right, 22nd.
Yeah.
All right.
Thank you, Judge.
It's Alonzo, Alonzo Taylor. What, contestant?
No. Reset.
I have a contested one.
All right, then we'll take your contested matter, but what's the reset?
It's Jonathan Alvarado's client, Caitlin Jeffries.
What page?
She's on page 19, Judge. 4 down.
And this is a probation. We reset after she was granted probation.
Okay. All right, so what is the status on the evaluation?
So Judge, one of the reasons it got reset was because Ms. Jeffrey was having her parole hearing in between last setting and this setting. She has had her parole hearing and they have decided to continue her on parole, but she is going to be sent to safety.
Okay,
One of the questions the court has was she had been referred for further evaluation regarding DDRF, and so the court was going to consider that depending on what happened at that parole hearing. Now, but given that she's been ordered for safety, as courts aware, that's a super long program of 9 months, I believe it is. I would just ask that she be allowed to start her probation once she gets out of safety, that she's already gonna have.
No, I mean, she will be on probation here already. It's just that
Right,
she's gonna have safe P.
as a condition.
Judge, I'm sorry, this is Caitlin.
Yes.
Okay, so Judge, there was, you just signed an order and amended conditions for her to do DDRF.
Okay.
There was a Tacoma already completed, I believe, and you signed paperwork just recently, maybe days ago, for DDRF, correct?
No, I never signed for DDR.
One second.
And
Ms. Abrams, maybe I have it wrong in my system.
consider if parole is gonna continue her without any added conditions, if the court was gonna allow her to do outpatient treatment as part of the probation.
All right, if you can do me a favor, just confer with Ms. Abrams and I can take up the plea for Mr. Woodard.
Yes, sir.
Matthew and Sariaga, court is calling 2025 CR 007924. State versus Matthew and Sariaga. Can I have parties announced for the record for the state? Defense,
David Andre Woodard for Matthew.
are you Matthew and Sariaga? Counsel, have you received all discovery that you review with your client?
I have, Judge.
Court will find the state is in compliance with discovery. Mr. Nsiriaga, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it? You're charged with aggravated sexual assault of a child. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Listen closely. 5 to 99 years or life. That's not exaggeration. That's Texas law. First-degree felonies give judges enormous discretion, and the judge makes one thing crystal clear. Even if you have a deal, the court doesn't owe you approval.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge, and he was.
Mr. Nsiriaga, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposed to your application. There's to be Chapter 62 compliance, no contact with the complainant, and you're subject to the full range of punishment if you fail to, do y'all mean this to say fail to appear for sentencing?
Yes.
All right, any objection to the court changing the word PSI to sentencing?
No objection from defense, Judge.
And state?
From state.
And you will be subject to the full range of punishment if you fail to appear for sentencing. So your plea will still stand. It's just that your agreement will change to you'll be subject to the full range of punishment instead of 10 years. Do you understand?
Matthew.
Sure.
So I will, probation.
No, this is what is going on. The state is opposed to the court granting you probation. You can still apply. but there's not an agreement. The state is not saying they want you to have probation. They're saying they do not want you to have probation. Do you understand? Now, with regards to you're not appearing, I'm going to give you a date to come back for sentencing. If you don't appear on that date, your plea bargain agreement for a cap of 10, which means that the state would only be able to ask for 10 years, will change to the state will be able to ask for life. Do you understand?
This may be the most high-stakes warning in the entire hearing. Miss your sentencing date, and your 10-year cap explodes into life in prison. No new crime required, no argument, just absence.
Did you understand that to be your plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? The waiver of appeal paragraph just tells you whether or not you have a right to appeal certain things. It's this paragraph. Did you review that with your attorney? Did you understand it and sign it? By signing that, you're waiving your right to appeal. The only items that can be appealed are motions that your attorney has filed, and I've ruled on them. Do you understand? Counsel, have there been any such motions?
No, Your Honor.
All right, then to what you're being charged with, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State it offers State's Exhibit 1 and all attachments, Your Honor.
No objections, Judge.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, you may be excused.
Judge.
Did you review this document called waiver and stipulations? Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, today there will be no witnesses, live witnesses. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you requesting a PSI and TAP evaluation?
I am, Judge.
Is there a need for a mental health evaluation?
I believe so, Judge.
All right, I need a PSI, TAP, and mental health evaluation, Ms. Abrams and Ms. Ferguson. What date?
I can do February 12th.
All right, once you sign the reset form, you are excused. I will base my decision upon your application upon any information that's given to me, all right?
So my brother, he's in the army, was gonna, like, how do I have him, like, get a contact with child support?
Oh, no, what will end up happening is you'll speak to your attorney about that. And whatever information you want me to know, just let your attorney know, and your attorney will let you know if they think it's appropriate for me to know about that or anything else. Just go through your attorney, okay?
And I want to,
I'm sorry, what?
can I ask one more thing?
Sure.
I was trying to see if the permission could go to my child's birthday.
Oh, you'll have to speak with your attorney, and your attorney will have to file a motion for that.
Yes, and I asked him, said he was gonna talk to, said he.
Okay. All right, and is the complainant the mother of this child?
Yeah.
Oh, no.
What do you mean?
I said the complainant in this case. All right, then your attorney, once your attorney confers with the state, the court will consider. All right, Ms. Ferguson, I'm sorry, what date?
February 12th.
All right, so we'll be back on February 12th, Mr. Woodard.
Okay, thanks, Judge.
All right, thank you. Once you sign that, you'll be excused.
Yeah, but